Good morning, everyone. Welcome to today's session on the new employment law. As always, thank you for your interest and attendance, and by the looks of it, by today's attendance, there's quite a lot of interest, so thanks for that. Just a quick look at the agenda. So I will try and stick to my 15 minutes. Just to give you a little bit of background in terms of our thinking and what went into the making of this new law, and also just a few indications of what really changed, but essentially just headline issues. We will then move on to, I think, what's sort of the main body of today's event, which is essentially myself sitting down with the panel of experts and asking them questions. The way that the questions would work is essentially we've agreed a number of questions that we will sort of discuss with them up front, particularly in relation to the main changes. And essentially, my expectation, if you want to put your hand up and correct somebody or say that's absolute nonsense, then fine. But my feeling is that we should go through those questions and let the panel of experts, provide their answers in respect of those questions, which will hopefully take about 45 minutes. I think that's what we've set aside for it. And then subsequent to that, we will then open up the floor for questions, and then essentially it's your chance to clarify or to get free legal advice if you wanted to today. And typically the way that I do it, because in the beginning there's obviously a lot of hands going up, so we sort of go by sections and then finish a particular section and then move on, and we will go through the room either until the time is up or no more hands go up. So that's sort of the way we see the panel discussion and the Q&A panning out. Just a quick other note from a privacy perspective. We're obviously recording these proceedings. Nowadays, everything ends up on social media platforms. The DIFC has its own. So, these will end up on media platforms. And obviously, if you have issues in terms of appearing, then I'd suggest you move, slightly further back so that the camera doesn't see you, or don't get up to ask questions if you have any privacy concerns. So just a quick look, because one of the questions that we often get to ask is why change, and why change now? People get used to what they have, and they operate within the context of that, and hence they don't like change. And also from a legal perspective, people like certainty. They like jurisdictions, and specifically common law jurisdictions predicate themselves on legal certainty. So you always have to be very careful in terms of why change. Now, we at the DIFC, from a sort of a legislative, philosophical perspective, we are reticent. I mean, we've been involved, I think, in about 26 or 27 projects over the past couple of years. But we are reticent when it comes to legislation from that perspective. But I think if you look at this particular law, there was a room for improvement. The original law was enacted in 2005. There was a revision in 2012, which meant we're sort of standing at another 7-year cycle. And if you look at the way that we internally look at legislation, we typically have a number of reasons why we want to change. Firstly, we typically look outwards, we benchmark, we look at what's happening in other jurisdictions. DIFC is obviously tries to hold itself out as sort of international best practice when it comes to being a financial center, and that pertains to everything, also employment. So there is an outward-looking exercise in terms of benchmarking. There's also an internal exercise where we have working group methodology. We look at what's happening, what's the feedback from the community, and what happens in the DIFC courts. What are the pressure points in respect of legislation, if you look at the matters that come up in disputes in the courts. And from that perspective, I think a lot of you in the room that have an understanding of the previous law and some of its issues, then you would say that both from a benchmarking perspective and from a sort of an introspection perspective, there was time, to look at this, anew and make changes, and that is what happened. And just the fact that it's a new law is we're not trying to, go off on a completely separate track. If you actually look at the law in itself is very much built in terms of the articles, the references, in terms of what the old law looked like. I think at some point it sort of goes out by one, but it's pretty much built on what there was previously. And it's just that we made so many changes that, had we shown you it as an amended law, the whole thing would have been read. So we just decided on that basis, or our legislative committee decided, that it's better as a new law. But it shouldn't be seen as a complete change from the past. Just in terms of a little bit of the process, once we had that sort of, benchmarking, a view of what's happening elsewhere and sort of an internal look, the process in itself, I think, in terms of changing this law, probably took about 3 years. This is not something that happened overnight. And there was an initial process where we went to, I know Shiraz, I saw him in the audience, there he is, to Stevenson Harwood when he was still there, and he sort of did the first iteration for us. And that came back with us. There was a lot of internalizing, a lot of discussion, because as you can imagine, the employment law is not just a legal issue. There's almost the social contract that comes into play, and a lot of emotional issues come into play. As a consequence, that came back internally. And when we did put that out to public consultation the first time, I think on a consolidated basis, we got about 100 pages of comments, just to give an idea of the feedback that was received. And what we then did is we basically engaged a group of employment lawyers to basically look at those issues, because on a number of the issues, what the feedback was like directly opposite. Some people said, no, you should do this, and other people said, no, you should do that. So from that perspective, we then sat with a group of employment lawyers, and in that context, the three panelists of today also played a very important role in terms of sort of leading some of the thinking and providing thought leadership as to what should be done. And from that point onwards, basically, we then asked Rebecca and Ben from Clyde Co to finalize the drafting on those points. And Gordon from Tamimi also played a very important role in that consultative process. And as a reason, we asked them to be here today. Just to have a quick look in terms of the law itself, I don't want to sort of preempt the discussion that is to follow. You will see us today, at least the panel of experts, focusing on a number of key issues. And by all means, those are the important issues. But if you go back to the consultation paper, and if you go to our website, there's an archived section that also has the employment law there and all the documents that were basically used in the process. And there's also a document called the roadmap to all the changes. So you can literally follow the roadmap and how everything happened. But you will note that there's ultimately 44 key changes being made to this document. So even though it may follow the structure of the previous law, I think if you start delving down into the detail, we've actually done a lot of changing. And the only reason why I point that out is we've given 90 days for this law to take effect. So the effective date is the 28th of August. And one of the key reasons being is to basically give you time to go and look at those changes and to make sure that in your respective organizations, that those changes are properly reflected also in your policies and procedures and your employment contracts. So it's important to do that exercise as far as I'm concerned. In terms of the main changes, those are the ones there, and you will see, it recurring in respect of the discussion points that we will have, with a panel of experts. I think just as a final point from my side, people may focus on some of the changes made in respect of this law on those that favor employees. And a very good example is the expansion of discrimination, the fact that there's now a penalty for discrimination. And there's a number of other changes that people can say, clearly DIFC basically, went down the track of becoming more employee friendly. But if you look at it carefully, there's also a number of other changes that are employer focused and making life easier for employers. And what we try to do is to basically a balancing act. And obviously time will tell, whether we succeeded in that or not. I think one of the other reasons why this law took so long is even once we basically finalized the thinking and around this, it still took quite some time for it to come to market, because by then we were sharing it with practitioners, and we were sharing it, and they were sharing it on a public platform, and we were still waiting for feedback on certain issues, ultimately to get that balancing act right. So that's basically it from me from an introductory perspective. And on that note, we will move on to our three panelists for today's discussion. I don't think any one of them, if you're in the employment business or you deal with employment lawyers, that any one of these guys need introduction. So I'm certainly not going to introduce you. And on that note, we will then constitute the panel and move from there. Okay. Can we just bring the chairs up? Okay, well, thank you everyone for attending and helping these guys out in providing a little bit more background and detail on specific questions. So from that perspective, Rebecca, and I'm old style, so it's ladies first, I'm sorry. My questions to you are the following. Question one is, under the current DIFC employment law, Article 18, and those of you who know Article 18, this is the penalty clause, has had some unintended and serious consequences for employers. Please could you explain some of the issues which have arisen under Article 18 and how the new law seeks to address those?
So, Jacques, as you said, the Article 18 is the penalty clause, and so under the current law, the provision is that an employer is supposed to pay an employee all monies due to that employee within 14 days of the termination date. And if the employer fails to pay all monies due, then the employer is obliged to pay a penalty of a day's wage for every day that the employer still owes that money to the employee. For those of you that have looked at this or dealt with it, you'll know it's been very problematic in the sense that there have been these unintended consequences that you mentioned. So, for example, if actually an employer simply makes an error in the calculation of the payments, or indeed even an error in the timing of the payments, no matter how small that money may be due to the employer is obliged to pay the penalty. And in addition, where there is a genuine dispute between the parties, it has been a bit of a a double or quits kind of issue for an employer, because actually if they dispute an issue with an employee but then lose, not only will the employer lose on that point of an argument, but they also then have to pay the penalty, because whatever it is that they didn't think they had to pay, turns out they did have to pay, and then they have to pay the penalty on top. So it's been an area, I suppose, of great industry for employment lawyers, and we've been very busy on this for quite a few years, and so sadly we're saying goodbye to this, so I'm saying goodbye to a whole chunk of work here. But the idea is that under the new law, the provisions now say, so Article 18 still says that you have to pay the monies, the employer has to pay monies owed to the employee within 14 days. In terms of what has to be paid, it is remuneration excluding additional allowances, and I'll come on to that, excluding additional payments, and also the employer has to pay gratuity and annual leave. And those payments still have to be paid within 14 days of the termination date. However, to address some of these concerns that have arisen when actually applying the old Article 18 in practice, there is now a minimal payment, so the monies due to the employee must be at least equal to an employee's wage, a weekly wage, and in addition, if there is a genuine dispute about the payments, which is pending before the court, then the court has discretion not to apply the penalty, and similarly, if actually the reason that there hasn't been that payment is because of the employee's unreasonable conduct, then again the court has discretion not to award the penalty. And by unreasonable conduct, just to give you an example, some of the sorts of issues that we have seen is, for example, where an employee refuses to accept the money because actually it's better to get the penalty than to receive the money. So those sorts of things will now be addressed, and the court now has that discretion to address it and not award the penalty.
Okay, thanks. The old Article 18, although harsh in certain circumstances, obviously made very sure that employees did get paid what they should be paid within that 14-day period. Does the new Article 18 then mean that employees will no longer have that protection?
No, so the new law does still ensure that an employee receives the monies due, and this goes back to the point I made earlier about what the law now says as to what is actually payable. So the law says that an employee is entitled to the remuneration excluding additional payments. And additional payments in this context is defined as commission, bonuses, anything which is not standard. So again, under the old law, one of the issues that we would see with for clients is if an employee is entitled to some sort of long-term incentive payment or some other payment where it's to be paid in the future and after termination. Under the old law, there would be a problem because you'd have to pay it within 14 days. Under the new law, that's now addressed. It doesn't fall within this requirement to pay within 14 days. But all other salary needs to be paid within 14 days. In addition, gratuity must be paid within 14 days and annual leave must be paid within 14 days. So actually, yes, there is still a requirement to pay monies within 14 days, and there's certainty now as to exactly what has to be paid.
Does the penalty still apply in certain circumstances for non-payment?
So yes, so where the employer fails to pay the remuneration, excluding additional pay, gratuity and annual leave within the 14-day period, then yes, that penalty will apply. And so the penalty continues to be a day's pay for every day that the employer fails to pay the monies.
Now, in the introductory part, we basically spoke about we're giving people 90 days to become acquainted with this law and to imply that back into their organizations. Can you give us a little bit of background what you think employers need to do to prepare for the changes introduced by the new law?
I think one of the key points is there is still the requirement to pay the monies to the employee within the 14-day period. So that hasn't gone away. So if as an employer you fail to correctly pay an employee within that 14-day period, you still face the penalty. and unless it's those very specific circumstances where the court has discretion to waive it, you will still have to pay that penalty. So actually, from an employer's perspective, you still need to be very clear as to what it is that you're paying to an employee. You still need to make sure you do it within 14 days. I suppose the only other thing that you now can think about is actually, are certain payments additional payments rather than the normal remuneration? And you will have to look at that quite carefully, and it will be on a case-by-case basis.
Okay. So one of the other key areas that we looked at very carefully, the old law had a lack of clarity to whom it actually applied. It basically said if you were working in the DIFC, in or from the DIFC for an employer in the DIFC, that basically created the employment relationship, and as a consequence the law applied. But we know in practice it's a little bit, more difficult to distinguish between people who come here on temporary assignments, secondees, etc. Can you give us a little bit of background how the new law deals with particular types of employees and what the consequences are under the law in respect of them?
So yes, this is a very good point. The old law, you had to look at is someone ordinarily working within or from the DIFC, and it really sort of ended there. Now there are, you still need to look at whether or not someone is an employee. So you will still look at is someone working ordinarily within or from the DIFC, or has the employment contract adopted the DIFC employment law, or thirdly, is somebody on a secondment. And a secondment is where somebody has a secondment card from the DIFC, so it's normally for a period of 12 months. Now, what the law has also addressed now is the fact that you can sometimes have someone on a secondment with a contract either onshore or outside of the UAE altogether. And so the idea is that if you are on a secondment with a secondee card or a secondment card, then certain of the provisions in the employment law will now not apply, and so the law actually specifies which ones. And I have to say, I'm not going to try and list them all because there's quite a lot of them, but there's now a list in the employment law as to which provisions in the law apply specifically to those on secondment. In addition, the law now also brings in the concept of part-time work. So it is possible for an employee to be working on a part-time basis, and the law defines that as either someone who works for less than 8 hours a day, or someone who works less than 5 days a week, or someone where the contractual terms specify that they are on a part-time basis. And essentially, there are quite a few provisions which explain it, but I can summarise it very quickly, which is you just prorate the entitlements. So depending on whether they're on reduced hours, reduced days, or a mix, it's a prorated basis for entitlements. And then finally, the third additional type of worker that we've looked at is those who are on a short-term basis. So essentially that means somebody who works in the DIFC and is an employee, but only for up to 30 days in a 12-month period. So in other words, somebody who comes in and out of the jurisdiction but is not here on a full-time basis, essentially. And again, certain provisions apply within the law, and we've specified that.
Finally, in terms of our list of prepared questions, the other key change in terms of application of the law and the remedies provided for under the law, there is now a 6-month limitation period. Can you just explain to us what that means in the context of claims and actions under the law, and how that compares with other jurisdictions?
So the old law didn't actually specify a limitation period. Now, I appreciate you can look elsewhere to work out what that was, but now the new employment law actually says, yes, you've got 6 months in which to bring a claim. So 6 months from the termination date is the period of time in which you need to bring a claim under the new employment law. In terms of how that compares with other jurisdictions, it's still actually quite a long period. So, for example, in the UK, for unfair dismissal claims, it's 3 months. Discrimination would be 6 months. So it's not wildly out of sync, but it's actually still quite generous when you look at other jurisdictions.
Thanks. Mr. Barr, your heading is family-friendly rights and discrimination. So that's where we're moving on to. I made a point earlier about the law trying to provide or create some sort of balance, better balance, between the interests of employers and those of employees. Can you explain to us some of the main changes that were made to the law to try and achieve this?
Sure, thanks, Jack. I should say before I start, I forgot my glasses this morning, so you're all just a sea of faces. So if anyone is grimacing at me about anything I say, then I can't see you anyway. And I say that because some of the changes are employee-friendly, as Jack mentioned. Some might be construed as employer-friendly. Some may be neutral. And everybody in this room is either, and in most cases, both an employer and an employee. So you'll have your particular views on some of the changes, and you'll like some of them and you may not like others. On the employee side, obviously Rebecca mentioned part-time working, which can be construed both ways, because if you were to employ somebody on a part-time basis now, that individual would have a right to the full statutory entitlements in terms of holidays, sick pay, maternity. And now, as Rebecca said, it's been prorated. So if you're employed on a part-time basis, you'll have a pro rata entitlement to those sums. Now, obviously that means a lesser entitlement for the individual, but if you're looking at it optimistically in the way I would say it's actually a positive change for employees, because you're more likely as an employer to want to promote part-time working within your organisation when you see that there's prorated entitlements as a result. The next headline grabber, which has obviously had some airtime in the press following the announcement of the new law, is around paternity leave. Again, it makes the DIFC much more consistent with other sophisticated jurisdictions where there is a provision for paternity leave. There wasn't under the old law. There now is a provision for 5 days paternity leave, 5 working days, provided the individual has at least 12 months of service. So again, a positive change, most of us would agree. Equally on maternity leave, although maternity leave provisions are largely the same, there is provision now for maternity leave where there's an adoption of a child under the age of 5 years old. Previously, it was under the age of 3 months old. So again, there's been an increase in that entitlement pursuant to the law. On the other side of the coin, obviously, the old law provided for what most of us would probably agree were pretty generous sick pay entitlements. The sick leave entitlement is still the same, 60 working days, but whereas before you could get full pay for your sick pay for that 60 days sick leave, it's now been reduced, and you would receive 10 days full pay, 20 days half pay, and then no pay for the final 30 days of your sick leave. Which is obviously a material change from what the law had in place previously. In terms of other changes that are on the sort of family-friendly area, there's obviously been a reduction as well in the amount of leave that can be carried forward. It used to be 20 days under the old law. It's now been reduced to 5 days. Many people in the room would have probably still had 5 days in your policies and procedures, so that might be a change that you don't need to affect. But under the old law, it was 20 days. It's now been reduced to 5 days. So that's a quick snapshot of some of the key changes in the family-friendly area.
Just on some of those points that Gordon made there, I think the key thing to remember, whether it's sick leave pay, and we can discuss that a little bit further, or whether it's what you can carry forward as your annual entitlement that you didn't use. What we are trying to do with the law is to put a minimum standard. Okay? So it does not, mean that you and your employer or employers and employees can agree to more generous terms, and we often see that. I think it's we wanted to set a minimum standard, and that standard is once again carried on the back of a benchmarking exercise. I don't know if any one of the panel members would just want to say, if you wanted to say, look at sick leave pay in a place like United Kingdom, Gordon, how it would work there.
Yeah, it's a fair point, Jack. And yeah, and although there's been a dilution in the statutory sick pay, as you say, the law provides, of course, that an employer can offer a more generous entitlement in the DIFC. In other jurisdictions, it remains largely on par. And when I say largely on par, in terms of what the new law says. So, for example, in the UK, the example you mentioned, there is statutory sick pay. It's a small amount. It's around £95 per week, which is about 500 dirhams a week is the statutory sick pay. So in terms of the benchmarking exercise you mentioned earlier, there is a similar type entitlement in other jurisdictions.
Okay, so moving on, I'm sure we'll come back to that one in the queue. But moving on to the other headline topic was the discrimination one, and the fact that we've expanded the grounds of discrimination and we've added a penalty. Can you just sort of take us through the main changes on what's been done there?
Sure. I mean, from my side, and I might be looking at it purely through an employment lawyer's lens, but I think that the changes to the discrimination provisions arguably represent the biggest change in the new DIFC employment law. We have had the anti-discrimination provisions in the law now since its inception, 2005. There hasn't been a successfully pled case before the DIFC courts in respect of discrimination with any award. There's a very obvious reason for that, is the law doesn't provide for any remedy. And as Jack mentioned earlier, the law now does provide for various remedies, including compensation. So that is a significant game changer from an HR and a legal function, cultures within the organisation, etc. Before we go back to those remedies, it's probably worthwhile just having a quick look at what other changes have been made to the discrimination provisions within the law. So in terms of the protected characteristics, so that's what somebody cannot be discriminated against: sex, race, nationality, marital status. There's been 3 additions to those protected characteristics: discrimination in respect of pregnancy, maternity, and age. And of those 3, I would suggest that age is the most groundbreaking, because arguably pregnancy and maternity would have still been covered by sex discrimination provisions in the existing law, whereas age, everybody has an age, and as a result of that, the stale pale male, as he may be referred to in other jurisdictions, who didn't have a discrimination claim, now potentially does. So that, I would say, is a significant change. And then we look at the actual types of discrimination. There's 4 types of discrimination. Direct discrimination, whereby somebody's treated less favourably than somebody else, and that could be by comments made to that person by a line manager by reason of some protected characteristic, being passed over for a promotion because of their sex, their age, their disability, whatever it might be. That's direct discrimination. The next limb is indirect discrimination. So where there's and the term is policy criterion or practice within the company which discriminates against one group of people over another. So the example I would use is, let's say Emirates have a policy about their pilots. Age 60, you can't fly a plane anymore. An employee who's 61 could conceivably turn around. I know Emirates aren't a licensee in the DIFC, so I can use this example. Emirates turn around and say, pilots turn around and says, well, I'm 61, this policy discriminates against me as against people who are younger than me and therefore have a discrimination claim. So that's an example of a policy which an employee might point to that says or argues it's discriminatory. There are responses and defences that an employer has to indirect discrimination claims. So is it a proportionate means of achieving a legitimate aim? So Emirates might well say, well, our legitimate aim is to protect the safety of our passengers. Is it? And then you have to say, okay, that's a proportionate aim. Is it a legitimate aim? Is it proportionate? You say there's a cut-off date at age 60. Emirates might well say, well, look, we've got all this evidence that shows after age 60 your reaction speeds diminish, whatever it might be that they use to support that legitimate aim. And that might mean they can defend a claim of that nature. Or there's a genuine occupational requirement. The obvious example would be used in other jurisdictions, say heavy manual lifting. It might be a case that the company would say, well, look, this heavy manual lifting, it can only be done by a male over a female, and that might provide a protection against an indirect discrimination claim. So that's the second area. The third one is harassment, and again, there was direct discrimination, indirect discrimination, and harassment in the old law. They've modified in the new law the test for harassment claims somewhat. Now the perception of the harassee, so the person who's being harassed, is also an important consideration. So if you have an overbearing line manager who's who's basically doesn't realise that he or she is harassing an employee, but the employee feels harassed, then that's an important consideration. What is also an important consideration is whether the conduct would justify that reaction. So that also has to be looked at. So if you had basically a thin-skinned employee who wasn't actually the subject of an overbearing line manager but just felt that, then the conduct that justifies that reaction would be insufficient to meet the test. So there are lots of moving parts around harassment now and what an employee would be able to make out in order to file a successful claim. And then finally, victimization, which is a new concept which the law has introduced, which basically means if I file a discrimination claim, or I give evidence in a discrimination claim, or I help somebody else file a discrimination claim, or I make an allegation of discrimination, anything that's concerned with the discrimination provisions themselves, and my employer dismisses me or I suffer a detriment as a result of my involvement, then I have a claim before the DIFC court. So that's a new concept which has been introduced, which again is not unfamiliar one in other jurisdictions, and so most would say it's a welcome move by the DIFC. And then that takes you on to remedy. So if it's a protected characteristic, you've suffered a detriment or dismissal by reason of any of those 4 areas of discrimination I mentioned, you bring an employee brings a claim. If that claim's successful, as Jack said earlier, you would be able to get up to a year's wage as compensation, or the court could give a declaration which says this person's been discriminated against or this policy is a discriminatory one, which can obviously have ripple effects, particularly for people in the room who have European or US parent companies. If you had a declaration of that nature, it could be very damaging. And then the third possible remedy is a recommendation by the court, which may be the employer should resist or desist from this type of practice or should change its policy. And if the employer doesn't act on that recommendation, the employee can come back to court and conceivably get up to another year's pay. So that's the remedies now at an employee's disposal. And obviously that has some far-reaching impacts in terms of how businesses organise themselves and protect themselves against any such claims.
Okay, thanks.